I'm Renee Galvan. I'm the president and CEO of HAR. I started with HAR in 1996, and I became executive vice president in 1998. HAR is already known as the greatest association in America, and I really just want to build on the foundation that has been built. Members are the heart of the organization, and I really want to hear from you to know what's working and what isn't, so we can continue to make HAR the very best. HAR's commitment to its members will never change. Technology might change, the market will change, but we will always be here to serve you. I met my wife at the University of Texas. We are both CPAs. One of my sons is a CPA, and my other son is an engineer. I guess that makes us a numbers family. HAR is here for you. I'm excited for what's ahead, and I'm honored to serve as the president and CEO of HAR.
Hi, HAR family. Leah Wynn here, proud TRLP graduate and your 2026 Professional Development Advisory Group Chair. Guess what? The moment you've been waiting for is finally here. Applications for the 2026 Texas Realtors Leadership Program are officially open. If you've ever thought, I want to step up and lead and make a bigger impact on real estate, this is your sign. TRLP is where you'll find your leadership voice, meet incredible peers who become lifelong friends, and unlock the confidence to take your career to the next level. Don't wait. The deadline to apply is March 20th, 2026. Head to trlp.har.com for all the details and get ready to start your leadership journey. This could be your year to shine, so go for it, and I'll see you on the leadership side.
In the beginning, when I was looking for a home, I was doing a lot of things on my own. That's when I started to work with a realtor. There's 100+ things to think about. Having somebody worry about all those things for you, it went from chaotic on my own to a more streamlined process for me.
Good morning and welcome to Member Focus Monday. I'm Christina Schaefer, Director of Social Media and Sponsorships for HAR. And today we're diving into a topic that every realtor needs to stay on top of: legal updates impacting our industry in 2026, from evolving rules and court decisions and changes to forms and procedures. There's a lot happening. And here to help us break it all down is HAR's legal counsel, Grant Harpold. Welcome back to the show, Grant.
Good morning, Christina. Good to be here. Always enjoy being with you and talking to our members.
Yes, and we'd love to have you. I think you're probably our most recurring guest that we have. I'll need to go back and count how many times we've had you on the program, because you always deliver such important, critical information for our members. But for anyone who hasn't heard from you before, Grant, tell us a little bit about yourself and your role and how it supports our members.
Well, that critical information comes from doing this sort of work for brokers for the past 30+ years. I represented brokers in all sorts of issues, claims, lawsuits, trials. I've been board certified in civil trial law since 1997, which is probably a handful of lawyers in the entire state have that distinction. And so I enjoy what I'm doing. I've done it a long time. I'm still doing it. And I'm a partner in the law firm of Buck Keenan. And and enjoy and love being legal counsel to HAR.
Thank you so much, Grant. So, new laws are taking effect this year. One example, a California law requiring disclosure when listing a photo that is digitally altered. And I know we see that quite a bit. What should realtors in Texas know about compliance and risk when they're using edited photos?
So that law is unique to California. So that
Hmm.
apply. It'd be like if Trek passed a law here, or if there was a new rule that came out of Trek, it would apply to Texas brokers and license holders. Same thing with respect to the California law. That applies to California license holders
Hmm.
doing business there. But I think the concept of it, meaning disclosure about using AI and about providing information to the consumer about how the AI may be affecting what the consumer is looking at, I think that's not a bad idea and a concept that
Hmm.
eventually may make it across the rest of the country, including Texas. So it's something that we as members, we as practitioners should consider doing now, if not already doing it. And that
Hmm.
is disclosure of use of AI in any sort of manner that is being publicized or being published to the consumer.
Hmm. Absolutely. And I mean, that's something that we've kind of discussed in the past too, even with photos that are digitally staged, right? You know, they've
Right,
digitally staged a pool in the backyard and that pool doesn't exist, right? So
right.
it's something we've definitely discussed before, but now it's an actual law in California.
It is, and I think, sort of in general, and NAR
Mhm.
has some guidelines on this. I mean, there should be some things you do relative to AI, and that being one of them is disclosing the use of AI. But also, if you do use AI, you need to be sure that it's accurate. Be sure that you summarize what you read the summary of what it's producing or what it's editing, however it's being used. And in my view, and remind everyone, all of the things I say on here, these are my opinions. I'm not giving
Right.
legal advice. I'm just providing an opinion. But I think, the use of AI is great. And I mean,
Hmm.
don't run away from it. As Bob Iger said, the ex-chair of Disney said, embrace technology as an opportunity. Don't run away from it. And
Hmm.
so I view AI in that same manner, is that it can be used effectively, but just understand how to use it and embrace what it provides, but also don't completely rely upon it. And don't,
Hmm.
you as practitioners can't use it to provide legal advice or something in that manner, but it's something that does provide another outlet of information for you, and use it, with respect and discretion.
Yeah, makes a lot of sense. Thank you so much, Grant. So, a recent settlement in the Baton Home Buyer Commission lawsuit made some headlines. What's the significance of that settlement for brokers and agents, and what should they think about that?
Well, I think for us here in Texas, it's limited application. I think Keller
Okay.
Williams reportedly paid 20 million to settle, and it
Hmm.
looks like they were doing that more as a just to buy peace and get out of the litigation and so forth. I mean, that
Hmm.
those claims, understand that the Batten cases involved claims from the buyer side of the transaction. The NAR settlement that we were all involved in came from the seller side of the transaction.
Hmm.
And so the buyer side is the buyer is saying, hey, I may have paid too high a price for this property because of the inflated cost of the commissions on the seller side. Well, that sort of claim does not exist in federal law. And it does exist in state law, but only in 23 states. Texas is
Hmm.
not one of them. So what we would call an indirect claim for antitrust violations of that nature do not exist in Texas, only exist in 23 states. And also, those claims that the buyers are bringing may already be covered by the NAR settlement. That's an issue
Hmm.
still to be decided by the appeals court. So, bottom line is, yes, it's something that's going on to pay attention to. But as far as application in Texas, it does not affect us since we do not have that type of law as a state statute.
Okay, great. Thank you so much, Grant. We had a question that came in going back to the AI disclosure that we were just discussing. The Schroeder team at JLA Realty said, is it necessary to give a detailed explanation of the AI use or just a statement that this image has been produced by AI?
I think it's simplification. Just make it simple, understanding, disclose it. One sentence is fine. It doesn't have to be a paragraph, in my view. Just, something practically speaking that advises the consumer that the AI is involved in this process or whatever is being provided to the consumer. There's an AI effect, and maybe, depending on how the AI is being used, there may be a disclaimer also to the fact that whoever uses this information should have it independently confirmed.
Yeah. Okay, very good. Thank you so much, Grant. So the FTC filed an antitrust lawsuit against Zillow and Redfin in late 2025. What are the core issues in that case, and why should realtors pay attention to that?
Well, there's three sort of internet advertising platforms that sort of dominate the market. One is Zillow, one is Redfin, and one is Apartments.com, CoStar. And so what happened here is that Zillow and Redfin got together and over a big bucket of money decided that Redfin would no longer be a player, that Zillow would take over that position. And so what it's effectively doing, allegedly, according to the FTC, is that it's shrinking the market and the competition. It's going to drive up advertising costs for internet listings and landlords who advertise. And if it drives up the cost for the landlord, it's going to drive up the cost for the tenant who's renting. So the FTC is taking the position that this sort of buy out the competitor sort of conduct, if you will, is anti-competitive, and that's why the FTC sued on this. And it remains to be seen how the court views this, whether that is in fact, anti-competitive or not. You would think that Zillow and Redfin vetted all those issues before they did this deal, but we don't know. So we'll see how that court case proceeds, and it's something that that would affect anyone, no matter here in Texas or across the country, because of the potential lack of competition for that advertising spot on an internet listing.
Okay. Thank you very much. And if there are any other questions for Grant, you can type those in and we'll get to as many as we can. Grant, the National Association of Realtors released an updated code of ethics January 1st, as I know you're well aware. What are some notable changes and how should members kind of prepare or fall in line, I guess, because now it's already in effect?
Well, it wasn't a big trough or bucket of changes, if you will, but specifically on the article, I think it was Article 7, that that you don't have to share the compensation terms with your client with all the parties to the transaction. The ethics code used to provide that you needed to, and now you don't need to. You just need to share that information, of course, with your client and nobody else. And there was also a move to say that referral fees would need to be disclosed to your client too. That particular part of the rewrite, if you will, was not passed. It did not pass the delegates. And so referral fee disclosure is a good idea, but NAR delegates decided not to pass that rule. And so technically, I guess it's still ethical to not have that referral fee disclosed to your client or to anyone. But in Texas, there is a truck rule that says you need to disclose referral fees and fees of any kind to your client. And so I think the better practice, even if it's not an NAR ethical rule or whatever, I think the best practice is to do what truck says. And that is, if you're getting a referral fee or some other compensation for services or anything related to some third party, disclose that to your client. Why not? Let them know that that's going on. It needs to be disclosed. And then finally, I think the NAR, they didn't change an ethical rule on this, but they reinforced the concept that if the client's interested in a property where you may not be compensated for what you need to be paid in the transaction as the buyer's agent, or there may not be any offer of compensation, or the compensation may be too small or something that perhaps doesn't get you excited about the transaction, you still need to show that property, provide that property to the client if it's something that they're interested in. So that's not something new, but they sort of reinforced that ethical application.
Okay. Great, thank you. Well, MLS rules continue to evolve as the industry shifts and, with settlements and things that are taking place. What are key changes HAR members should be following, especially regarding written agreements and compensation communication?
Well, I think the showing agreement is the big one right now in the buyer rep agreement that, before you show if you're working with a buyer and you're not representing the seller, before you show a property to your client or potential client or unrepresented buyer, that you need to have a showing agreement in place. And the showing agreement is fairly simple. It's just that, it has a limited time, 14 days max. It's not exclusive. It should identify the property you're showing. Maybe there's compensation, maybe there's not. And it sets forth the limitations of what you're actually doing, meaning you're not technically representing them as a fiduciary at this point. It's simply a showing agreement, but it's something that needs to be in place if you're working with the buyer before you show them their property. And so if you're the seller, if you represent the seller in the transaction, and you can see it on the screen here, if you represent the seller in the transaction, it means that you're working with the seller, you're not working with the buyer. And so you don't have to have, in my opinion, you don't have to have a showing agreement with the buyer, because you're already working with the seller and have an agreement with the seller to work on their behalf in the transaction. And that would apply also to a open house or to any sort of unrepresented buyer where you represent the seller. And so, I think the intent of the rule or the statute is to provide guidance for those buyers who are unrepresented, and you as a license holder are not representing anybody in the transaction either, and that you decide to provide this showing. You need the agreement. If nothing happens after that showing, then that's sort of the end of the process. But if that relationship develops into something that provides or more brokerage services or even leads to an offer, then you need a buyer rep agreement in place before the offer is made. And so that a little bit complicated, a little bit regulated, if you will, but that is what it is.
Yeah, absolutely. A question just came in from Beth. She said that also applies to showing a property to a tenant as well, correct?
No, it does not. On commercial transactions and on rental transactions, it does not apply. It's strictly on the sale of property. So
Okay.
good question.
Yes.
Thanks for making that distinction for us. Yes.
Yes, thank you, Beth. And another question here, does that apply if you are holding an open house for another broker?
Well, it's a good question. If, sub-agency still exists, it may not be in the IABS anymore, but sub-agency as a theory of law still exists. So if you have an agreement with the listing side, the broker or the seller, to show the property as a representative of the seller, then no, you don't need an agreement. But if you don't have that relationship with the selling side, meaning you're not working on behalf of the seller, then yes, you would need an agreement, showing agreement or some sort of agreement, buyer rep agreement, before you show that property, or before even at an open house for that person who shows up unrepresented.
Great. So then we have another one, and that just came in, I'm sorry, from YouTube. Kim is asking if you're doing an open house for another broker at your brokerage, does it apply?
Well, no, because again, here's the key. If you represent the seller in the transaction, from my view, you don't need to enter into agreement. It would be almost conflicting to have now saying that you're working on both sides. No, if you're working for the seller, if you represent the seller, if you have an agreement with the seller, then the buyer, the unrepresented buyer, you do not need to have an agreement with that person, because the intent of the statute is, as I read it, does not say that.
Okay. And there was another question, a follow-up. Would this all need to be documented?
Well, as a general rule, we all like to see documentation of whatever we do. So yes, to be clear, and that raises a good point. If you are representing the seller in a transaction and you have an unrepresented buyer, you have to disclose that fact. that you
Mm-hmm.
represent the seller. So that needs to be disclosed, and it's best to disclose that in writing. And there's a forum for that, but in some manner that needs to be disclosed, and it could be verbally, but it's best to be done in writing.
Okay. Cindy asked, what if they refuse to sign anything?
Well, they being the unrepresented buyer,
Mm-hmm.
if you're on the selling side and you represent the seller, then that's a non-issue. But if you're not on the selling side and you don't represent anybody in the transaction, and the buyer is interested in seeing a property but will not sign the showing agreement, then you cannot show them that property. You
Mm-hmm.
need to, as an unrepresented buyer and you're not representing anybody in the transaction, you need to have that showing agreement in place. If the buyer says, no, I'm not signing that, then, in the conversation.
Yeah. Okay, very good. And one more little follow up here on this topic. Bridget said, to be clear, if you are an agent hosting an open house for another brokerage, anyone who comes through the door must sign an agreement?
What I said, sub agencies still exist. So you can
Mm-hmm.
still be, even though you're an agent from another brokerage, if you have an agreement with that listing broker or the seller to sit at that open house as a representative of the seller, then whoever shows up unrepresented, you don't need to sign an agreement with them. But if
Mm-hmm.
you're an agent sitting at an open house and you have no agreement with the selling side, you're just doing this as a matter of courtesy, which it seems odd to me that you would do that, but I know it goes on. There's legal risk in that effect and E&O
Mm.
coverage issues and so forth. But whatever, if that's the situation where you're sitting there not representing anybody but holding the open house, then yes, unrepresented buyer comes in, then a showing agreement needs to be in place.
Very good. Thank you so much. And thank you for clarifying, Bridget says in the comments. So great. Thank you so much, Grant. I know that's, we see a lot of questions around that topic. And I think it's
Yeah.
important just to clear it all up so that everybody understands and they're following the protocols as
You're
written.
right, Christina. You're totally right. I mean,
Hmm.
when I read it, it's not exactly clear. So
Hmm.
don't beat yourself up, practitioner, for not fully understanding what the statute is or how it's being told to you, because it's a
Hmm.
little bit, it's a little wordy, or maybe
Yeah.
needs to be more wordy, perhaps. I mean, so anyway, go ahead.
Very good. Well, you mentioned or somebody asked about documenting. Excuse me. Carolina asked, how long would you recommend holding on to a rep agreement? If I show a property to a client once and never again, do I need to keep the document for years?
Hey, well, that's a good question. So
Hmm.
your broker should have a office policy, if you will, on
Yeah.
retention of documents relative to a transaction or relative to, the conduct of business. So I would defer to your office policy on retention of documents. But yes, to
Yeah.
some degree, you would want to hang on to that document for some period of time
Hmm.
that just in case, even though it seems like a remote process that might come up, but still, I would hang on
Hmm.
to it or whatever your broker says, or at least for a couple of years, in my view.
Yeah, absolutely. Okay, great. And one more question here. Bridge is asking, do we have a new form in the works for agents of other brokerages who host open houses for other brokerages?
We being me, no, I'm not. I don't have a form in place, but I'll think about that. I'm not aware. It's a good question.
Yeah.
I'm not aware of TR either having an existing form or creating a form for that situation, but maybe there should be, or maybe there is.
Mm,
It's not a hard concept to put on paper.
yeah. Yeah. Well, if somebody knows of one, put it in the comments for us. But great question slash suggestion there, Bridget. So beyond the specific cases that we were discussing a little bit earlier, are there emerging legal trends or risks that you are watching that could affect our members in the near future?
Well, look, do you have that lawsuit update? Is that on
I
there?
do. Yeah,
Yeah,
absolutely.
let's look at that. We talked this just sort of a landscape of what's going on out there, And we talked about the FTC case, and let me just mention this Compass Zillow case, which is a effort to challenge the clear cooperation policy, meaning that Compass, or Zillow taking the position that if there's a private listing and it starts to be marketed to the public, then it has to be put in the MLS within 1 day. And if it doesn't, then it's not going to be shown or listed or provided or publicized on Zillow. That's what the Compass v. Zillow case is about. Here recently, I think just earlier this month, Compass sought an injunction to stop the enforcement of the clear cooperation rule, and the court in Washington denied that injunction because one of the ways to get an injunction, you got to show to the court that you're likely to win the lawsuit, and the court was not convinced that the Compass had shown that in this case, that it was likely to win the lawsuit. So the court was not going to go ahead and put an injunction in right now on something that didn't, to the court, look like it would likely succeed. So what does that mean is that the litigation goes on. And so one day probably not in the near future, one day from a year from now or so forth, there might be a trial on seeking the injunction that they sought the other day that was denied by the court. Mm-hmm. And so that's out there. And then for all of us, the NAR settlement, it was sort of if you winked, you missed it, or there was a hearing on the appeal of the NAR settlement. So remember, the NAR settlement that all affected or changed the way we do business to a material extent, that settlement is on appeal from various parties attacking that it was unfair, that it didn't provide enough recovery for the plaintiffs and so forth. And so it's sitting in the Court of Appeals in St. Louis. And the other day they had an oral hearing on the appeal, and it was much to do about nothing, meaning there was nothing that came out of the oral hearing that suggested any which way that the Court of Appeals is thinking or viewing the court or viewing the case. So it lives on. The settlement is still on appeal. There was nothing that came out of the hearings that suggested which way the court is leaning. I think ultimately, whatever the court does, it doesn't necessarily affect the merits of the appeal as far as the causes of action and the antitrust and the things that changed in our industry. What would change would just be how the money is split between the consumers, the lawyers, the plaintiffs, the non-plaintiffs, and so forth.
Okay. Great. Thank you so much. And I was briefly showing a couple of slides there that Grant provided. He actually provided about 10 slides that I think are really helpful. We can share a link to those in the comments. And we have a PowerPoint version and a PDF version. So whatever is easiest for you. For brokers, this might be something that you want to go over with your agents in your Tuesday meetings, just to keep them aware if they missed today's episode. So we just shared the link in the comments for you to see a PDF version of Grant's slides and a PowerPoint version as well. So for day-to-day practice, Grant, what are some of the most common legal pitfalls you see agents encounter, and how can they protect themselves?
Well, I think it's what I see is communication or lack thereof, and accuracy or lack of confirmation or making sure it is what it is. And by example, I've seen or been involved in lawsuits of late where the MLS input sheet, and specifically the area where the restrictions and that nature, that column of boxes to check and so forth, sometimes get checked inappropriately or not accurately. And the seller signs off on the MLS input sheet, but the seller, I'm not sure, really reads it or understands it. And so there may be an inaccuracy in the MLS input sheet. And then down the road, the buyer's agent or whoever, but most likely the buyer's agent, prints MLS input sheet out and hands it to the client. The client sees something that's inaccurate in there, let's say with regards to restrictions. And that could lead to a claim of some nature if what appears in the MLS input sheet that's now in a printout is different than what actually exists at the property. So that's again, the lesson there is that's an important document. Make sure it's accurate and make sure that the seller understands what it's signing off on. And then also seller disclosure notice. I mean, another thing I still see in seller disclosure notices is that they're not completed.
Yeah.
Sometimes they're provided and there's areas that were skipped or not completed, meaning that it just wasn't answered, or better, it just wasn't completed in full. And what I mean by that is if there's a comment section for based on a disclosure that was made or a box that was checked and provides a section for comments, then there should be some comments from the seller on what they mean by what was checked. And the comments should be explanatory. They should be not like one word sentences. They should explain or expand upon, if you will, what the notice was checked or what the box was checked and why, and here's why that box was checked, and explain it. And if you as a listing agent should make sure that the seller disclosure notice is completed in full, and B, certainly on the sensitive things like flooding, and there's a box checked about flooding that is explained in a relatively easy manner in the comment section. And so sometimes that's missed. And so I think those are, again, back to being, having good communication and being accurate.
Yeah, very good. Thank you so much, Grant. I failed to include this in my questions for you, but I'm going to ask it now because we do see this come up from time to time. It actually came up last week in the Platinum Subscribers Facebook group. Why don't we require the listing agent input a seller's disclosure notice when they input their listing? I know that you've often been in the room when this has been discussed with the MLS advisory group. Why is there no requirement for that when somebody inputs a listing in the MLS?
Well, you're putting me on the spot, Christina. I might defer to the MLS advisory group on that.
Okay.
A collective body of intelligent individuals that have not gone to that extent, but I'm sure there's good reasons why not. But I mean, I think it's ultimately the understanding in doing that is getting that information to the buyer and to the buyer's agent from the very beginning and from the beginning of the process. So in theory, the concept is not a bad idea because that information is there and it's ready to go, and it's something that the other side, the buyer side, can see from the very beginning of the process and not have to wait until they are given it by the listing agent or obtain it some other manner. So in theory, it's not a bad idea, but there may be practical reasons why it's still where it is right now, and that is that it's not a requirement.
Okay, very good. Thank you so much. I have a few more questions for you. I know we're almost over time now, but I have a few more questions for you. So this is a lot, right? You provided some wonderful slides for us that I think will be really helpful to anyone that wants to review this information, or if they rewatch this, it's basically notes of this conversation. But how can realtors stay informed about ongoing new legal developments through some of the HAR resources?
Watch Facebook Monday when I'm on it. No, always watch Facebook Monday because there's all sorts of information, whether it be from me or from other people within the industry that Christina has on here that is very informative. And so I think it's stay informed. Read the emails that come out from HAR that about things that are going on, and attend, engage. There's all sorts of advisory groups to be a member of to gain understanding and be a leader in some of these issues, risk management, stuff like that. So I mean, there's a whole host of information out there whether on HAR.com or being sent out by HAR that provides information that is valuable and is helpful. And so slow down a little bit, stop and take time to understand and stay in tune to what's going on around you, and reach out to me if you need something else. I mean, so I'm always available too. So I don't think there's a I don't think there's a lack of information. I think it's there. It's just a matter of taking the time to
Hmm.
enjoy it, read it, understand it, use it, and so forth.
Yeah, very good. But there are resources available, so we recommend that you guys use them. A great question just came in from Fernando, and I do see this question from time to time, so I want to just bring it up now. He is asking, there are two seller disclosures, one from Trek and one from TR, which provides more detail. Which would you recommend? And that's the case for a few forms. So in general, do you recommend that our members use the Trek or the TR form?
Well, the TR form is a little more thorough, ask a
Hmm.
few more questions, and is more comprehensive, if you will. And so that tends to be the best form to use because of the theory and providing the consumer as much information as possible. And so
Hmm.
the TR form provides more information. So in theory, that's a good thing for the consumer to gobble up as much information as it can concerning the property that the seller is providing. And
Hmm.
so, uh, from a practice standpoint, it would seem that the TR form is the form or the standard to use because by its very nature, it's more comprehensive.
Mhm. Very good. Thank you so much. Well, Grant, again, we're not looking for your legal advice, official legal advice here, right? But do you have any, maybe one piece of advice that you'd give realtors to help them just navigate this year with confidence?
Well, I mean, I think what you said is be confident. And the way to
Hmm.
be confident is be informed. And that's kind of what we've been talking about here and why you're watching this program is to stay
Hmm.
informed, be confident in your abilities, and I guess I would say it this way: be the professional in the room. You know, you are the professional, so be the professional in the room. Sometimes,
Hmm.
whether on the buyer side or on the listing side, there's emotions involved in this for the seller to sell a house, for a buyer to buy a house, and so it can get emotional. And so,
Hmm.
the client on either end is looking to you, the professional, to be the steady person, to be the person who's communicating good information, be the person providing good advice. And so, in order to do that, you need to stay informed and be involved in what you're doing, and just to have that presence of being a professional and acting like a professional and instilling confidence in your client.
Yeah, very good. There was a question, and I saw a few people asking something around this topic on signs. And I don't know if this is really a question for you, Grant, but if it's not, we will make sure to get them an answer in the comments. Bandit signs. Is there a formal definition of bandit signs? And how can our members avoid violating that new law?
I'm not. I don't. I don't know that there's a formal definition of bandit
Mm-mm,
signs, and I haven't seen anything. You
mm-mm.
know, here I try to stay informed too, believe it or not, and I haven't seen anything on that, or I would certainly relay that to you. But I don't want to say
Yeah.
something without having really been informed on that issue. But I
Mhm.
haven't come across anything of late on that issue.
Yeah, I agree. I haven't really seen any formal definition of it. We just recommend that our members, if you're putting out those signs, I think what we've said is just make sure you're cleaning them up so that you're not getting yourself in trouble. But we haven't really heard many reports of realtors being targeted around this. I don't believe. Have you heard anything about that?
No, no, I have
Yeah.
not, and I don't know that I'm always the first to hear, but at some point I tend to you know, be advised of those things, and I have not seen that. So,
Yeah.
I got my eyes wide open and my ears open.
Great.
I'm ready. Yeah.
And I know our governmental affairs team, they're on top of those issues to make sure that realtors are protected. So, but thank you for the question, because it is one that we often get. Well, Grant, again, so much great information. This is why we love having you on the show. Is there anything else that you want to share with our members today?
I just can't believe it's over. I mean, we just got started. I'm just getting warmed up. And but like I said, I enjoy doing this. I've been doing it a long time. I'm here to help, and and 2026, I think, is going to be a good year, but there's always challenges in everything we do, and so
Hmm.
uh, don't be surprised to be challenged and rise to the occasion and be a professional.
Yeah, wonderful. Well, thank you so much for the update. The thank yous are rolling in. We've got some clapping hand emojis. Vara said, "I love when you're on the show." So thank you again, Grant, for helping us make sense of all these important updates. Like you said, staying informed is just one of the best ways to protect yourself and your business. So, and to better serve your clients. So we appreciate your time and efforts here, Grant.
Thank you, Christina. You do a great job as usual. I appreciate you allowing me to be on here.
Of course. Thank you. And you know I'll be calling you whenever there's new updates. Well, that's it for this Member Focus Monday. We will be back next week at 9 a.m. Have a great week, everyone. Bye-bye.